Good afternoon, everybody. We're going to get started in just about a minute. We see some folks trickling in. Welcome to our January Lunch and Learn series. Today we're going to be talking about Child Permanency Mediation. We're joined by the Court Improvement Program. And just because I know we've got a lot of content ahead of us, I'm going to get us started. My name is Rae Glaser. I am the director of the New York State Kinship Navigator Program. Again, welcome to our Lunch and Learn series. Once a month, we do a topic overview on something that's of interest to kinship care providers, and kinship caregivers. This month, we're going to be talking about child permanency mediation. All of our Lunch and Learn series are right here on the slide. This will be sent out to everybody after the webinar. And just a reminder for those of us that have joined before, if you're new to our series, this will be recorded. So we are in a webinar situation. If you have a question, feel free to drop it in the chat. We will answer it at the end of the session. Everybody is muted on this webinar, so we won't have the opportunity for back and forth. But all of our contact information is on the slide deck, which, as I said, will be recorded and sent to you post-webinar. So as you can see, we've had a series of Lunch and Learns over the past 9 months. We've got a whole bunch of information here. It's available if you click on the link on the Navigator's YouTube video site and on the Navigator's website. Next month, February 17th, we will be joined by the New York State Office of Aging to talk about how they can assist with kinship caregivers and their kinship caregiver programs. So as I said, my name is Rae Glaser. I am the director of the New York State Kinship Navigator. We are the host of these Lunch and Learn series. We are information, referral, and education for kinship caregivers all across New York State. Our primary goal is to connect caregivers to available financial assistance, legal advocacy, make referrals for caregivers that are beneficial to them within our system of care to local kinship programs, permanency resource centers, other kinship resources, and other referrals that will be useful to them. You can see right here, our helpline is open Monday through Friday, 10 to 4, 877-454-6463, and our website, www.nysnavigator.org. Here's a screenshot of our website. On our site, you can find information about kinship resources in your area. You can see our map. If you put in your county and what type of service you're looking for, it will give you information on what's available to you. We have headline news right on our homepage, information about upcoming events. We do have legal fact sheets under our legal resource column, information on caregiving, facets of caregiving, how to access financial assistance, legal assistance, different types of legal designations for caregivers, enrolling children into school, getting passports, official documents. We also do have online chat available on our website, 10 to 4, Monday through Friday. You can just go right to our homepage and there's a button where you can click to chat with a Kinship Navigator. A lot of professionals find this really helpful to link clients to their services, but it's very available to anybody that's looking for information. Navigator's primary purpose, as I said, is information, referral, and education. We do intakes in 37 different languages for caregivers, find out a little bit more about what their caregiving situation is, where they're calling from, what they're looking for assistance with, so that we can provide information to the caregiver on what they're looking for, most commonly information on financial assistance, legal options for caregivers, enrolling children into school, obtaining documents, things of that nature. And then we do partner with many referral agencies across the state. Like I said, Kinship Navigator programs, support groups, we have legal referral network access. We also provide education across the state, Lunch and Learn series such as this one, presentations on Kinship 101, financial assistance, KinGap, legal options, basically anything your agency is looking for kinship related. We are more than able to come out and present to you or present through the comfort of your computer screen. We do provide advocacy across the state, case by case for caregivers, and then we have statewide advocacy via our KinCare Coalition, which is comprised of the Navigator and several partnering agencies with an interest in kinship care across the state. I've got the link for the KinCare Coalition right on this slide. Take a look. We are right in the middle of policy and budget season and legislative action. Our Kinship Education Day is on February 15th this year. There's information on how to register. It is virtual, and we encourage you to attend. One other additional piece of the Kinship Navigator program is our virtual case management. In counties where there is not a local kinship program that is funded by the Office of Children and Family Services, we have on-site virtual case managers that can assist you with your kinship needs. They stay on your case for 6 months. They can help with facilitated benefits applications, referrals, follow-ups, anything that you need that is more extensive than calling our helpline. As of right now, the counties listed on this slide have available to the kinship caregivers in that county virtual case management. We are always expanding that. If you're a kinship caregiver or know of a kinship caregiver from one of those counties, you don't need to do anything special other than call our helpline or get in contact with the Kinship Navigator, and we will provide that for you as an option. For the professionals out there, our permission to contact form is something that's been really helpful. This allows the navigator to reach out to a caregiver without the caregiver having to call our helpline directly. It's available right on our website. It is a form that you have the caregiver fill out, sign, fax to the navigator, and we will call that caregiver within 48 hours to do an intake. If it's an emergency, just write urgent on the top, and we will reach out the exact same day to call the caregiver. Basically, what this does is it takes the onus off the caregiver and allows the navigator to reach right out to that caregiver. Right on our homepage, it's available as well. Feel free to click, download, send it to us. We'd be more than happy to reach out to a caregiver on their behalf. Also on our website are brochures, posters, other outreach materials that we are happy to send out. If you've got questions, feel free to get in contact with us. We're more than happy to send those out in bulk. I'd like to turn it over at this point to Anna Wilkinson from the Court Improvement Project to talk a little bit about child permanency mediation. Thanks for joining us today, Anna.
Thank you so much, Rae, for having us today. I'm here with my coworker, Sue Shafer, and we're going to go through Child Permanency Mediation Program. Again, thank you so much for Rae for having us. We love the Kinship Navigator program, all the services you offer. They're so invaluable, and we love partnering with you. If you want to go to the next slide, thank you. So what is mediation? It's basically a dispute resolution process. Mediators are a neutral third party. They do not give advice. Oftentimes, when speaking about matters that would be appropriate for mediation, people are extremely passionate. So they tend to talk over each other and may not listen to each other. The mediator is able to remove any tension that might be felt by participants and provide a neutral voice. All cases must, to be eligible for permanency mediation, all cases must have its origins in child welfare and must be under the court's jurisdiction. This means that when having permanency mediation cases, those attending would be people from the local social services, any associating attorneys, foster parents, etc. Cases that are Article 6 may only be heard if they originally stemmed from an abuse neglect case. All other Article 6 matters would be heard at our local Center for Dispute Resolution centers. So what does mediation look like? Everyone really wants it to look like what's on the left-hand side, what's on the left-hand side. Unfortunately, what normally happens is the top right-hand corner, but our ultimate goal is to try to get to this bottom right-hand corner. So mediation versus negotiation. Negotiation, people have to give things up. In mediation, we are not asking anyone to give anything up. Rather, we're asking you to think outside of the box and come up with a solution that meets everyone's needs. Family Court Act 1018. This is just the act that allows family court judges to order mediation. What this also means is once you show up and hear the opening statement, the rest becomes voluntary. Confidentiality. This means mediators cannot be called to testify, and no one can tell the judge what's said during mediation, as the judge would hold this inadmissible. There are exceptions which are listed above. Because there's always a mandated reporter in the room, if any new allegations come up, the meeting would be immediately stopped and a conversation would happen about next steps. The same thing would happen if serious concerns of harm are brought up. When mediation is completed, everyone does get a copy of the written agreement, including the court, as they're the ones who made the referral. When discussing capacity issues, any other type of mediation, any one of these capacity issues might rule the case out. But as we know in child welfare land, many of our cases have one or more of these capacity issues, and permanency mediation is able to deal with them. For instance, in a DV matter, domestic violence, there could be 2 mediators, 2 mediations. This is happening a lot less frequently, or is easier to manage with it being virtual. Always keep in mind that parties are represented, so if anything comes up, legal representation is there. And I'm going to pass it to Sue.
Thanks, Anna. So the mediation process, all referrals have to come from the court because these are under court's jurisdiction. It has to be the court that's referring the case, but anybody can ask. So any parties can say, you know what, I'd really like this to go to mediation. What happens is the court will fill out the referral, which is that picture there on the right, and send it into permanency mediation at nycourts.gov. Once the referral comes in, a mediator is assigned. There is a roster of 26 mediators. So we pick a host mediator and then we pick a co-mediator because it is a co-mediation model session. The mediator will then reach out to all of the parties because usually email addresses are there, and they'll send them a link for the mediation because at this time it's virtual. Once the mediation occurs, a report is sent to all of the parties, and if there's an agreement, the mediator writes it up and also sends that to all of the parties. Then the case is closed and the mediator is done. So parties to the mediation who will be there, as Anna had said, it's under the court's jurisdiction. So everybody who is a party to the mediation is going to be there. Their name is going to be on that referral form. So that means all of the attorneys, it means the respondent parents, it means the Department of Social Services. Who should be there really depends on the issue. So parents are more than welcome to bring support members or family members if they feel like they, want them there in the mediation. Foster parents, if it's, for instance, a conditional surrender and the foster parents are pre-adoptive, we think that foster parents should be there as well. So it's really surrounding what the issue. It could be an issue about service providers. So then, let's have the service provider there. So it's whoever's ingrained in that issue that needs to be there. The other key point about parties to the mediation is decision makers. So lots of times you'll get a caseworker who's there who can't make decisions. What we usually say is we can take a break so they can go reach out to their supervisor. We can get them on the phone if they need to do that. But it's the decision makers, because you don't want to go to a mediation and have everybody have a conversation and so yes, we're going to agree to this. And all of a sudden one party says, you know what, I don't know if I can agree to that. I have to take it back. That's not how it works. We want the decision makers at the table. So when we reach an agreement, it's an agreement for everybody. And we all know when we leave that mediation that that's going to go forward. So as I said, there's 26 mediators on a statewide roster. That means if a mediation occurs in Buffalo, the mediator could be from Albany or from New York City, right? We don't know where they're coming from. They're all across the state. They all are New York State residents though. Mediators have to go through a series of training in order to get on the roster. The first one is basic mediation training, which is anywhere from 24 to 32 hours. Once they do basic mediation training, which teaches them how do you mediate, right? It's your basics, the fundamentals. They then have to do an apprenticeship. And usually that's with the local community dispute resolution center or wherever they get the mediation training. So an apprenticeship usually consists of observing a couple cases and then co-mediating and then being observed yourself to make sure that you have all of the skills and the foundation down and you can proceed. So all of our mediators have basic mediation. They also have family mediation training, which is anywhere from 16 to 24 hours training. And that's your parenting plans, your custody visitation, your support. So they're trained in basics on what they need to know about mediating those family type cases. And again, they go through an apprenticeship program. The child permanency mediation training, if mediators have those other two trainings, they can apply when we have a training. And what it consists of is about 36 hours. It is a full week. And they get training on trauma-informed care and solution-focused strategies. They get cultural humility, implicit bias. They get family court legal 101, large group facilitation, and then neutrality and ethics. So I want to kind of just go through a little bit of the research. All of this research is national. And I do not have the link in the PowerPoint, but if anybody's interested, please reach out and I will send you all of the articles and the research. So for cases that are mediated, children spend less time in out-of-home care. The compliance with the service plan usually is better with mediated cases. Cases that are mediated have more likely to have children placed with relatives. There are less court hearings for mediated cases. So mediation can be effective at all stages, from initial proceeding all the way to pre-adoption, post-adoption. Mediation is an engagement strategy. So OCFS is really big on engagement strategies. Mediation is an engagement strategy. There's more flexibility in agreements. And from doing surveys, parents report feeling heard after mediation. So I did put the 2020 statistics down to compare them with the 2019. I do not have 2021 statistics only because I still have a couple open cases still. So I do apologize for that. I do know that we had more cases referred in 2021 than we did in 2020. Statewide last year, or 2020, there were 100 cases referred. 13 of them were canceled due to COVID, compared to 2019 when there were 130 cases referred. We were down from March until about July. There were no referrals accepted from March until July because the courts closed in 2020. So even with that, 4 months of being closed, I think 100 cases referred were still pretty good, as opposed to the 130. I think if we had been open that whole entire time, it probably would have been higher. The mediation rate actually went up in 2020 to 80%, whereas in 2019 it was 77. Mediation rate looks at how many cases actually attend the mediation and proceed. So of the cases that were referred, 80% actually mediated. And then the agreement rate also went up. So that was 76% for 2020 as opposed to 73 in 2019. What that means is 76% of the 80% that mediated, so 76% of that reached an agreement. So most people enjoy this portion, so I'm going to kind of fly through. They really want to know what the case examples are. What types of cases have been mediated? What were the outcomes? So there was one case, the child was ready to be returned. They had a court hearing. And at the court hearing, the caseworker said, you know what, I'm not really comfortable returning the child today. We've heard there's allegations of mom using drugs. So the judge called up and said, I know you don't do on-the-spot mediations, but this is the case I have in front of me. And can you come down and do this? So obviously, it was the court I was located in. So I said, yes. So I went downstairs and mediated the case. It ended up being that the child did go home that day. What they agreed to was that mom would go and get a random drug screen. And if it came back negative, the child would go home and mom continued doing drug screens randomly whenever the caseworker asked. And that was the agreement they came up with so that child can be returned home. If we didn't do mediation that day, that child would have stayed in care. They would have adjourned the hearing and kept having to bring them back until they got it resolved. But because they went to mediation, they were able to resolve that and the child got to go home. A parenting class focuses on early development. So this was a very interesting case. The mom had parenting class. That was the last thing she had to complete in order for all of her services to be done. And the caseworker would make parenting referrals for her to go to a parenting class. She would start it and then she would stop and she would drop out. And the caseworker was really frustrated. And she's like, I don't understand. Like, this is the last thing you have to complete. Like, why can't we just get this done? And what came out at mediation was that mom said, these parenting classes you keep sending me to are for infants and toddlers, and my child is a preteen, and it's a waste of my time. Like, I don't see why I need to go doing this. So what ended up happening was they came up with an agreement. In this specific county, they have what they call parent aides, which are individuals that work with the respondent parents. They go into the home, work with them on cleaning and budgeting and shopping and household stuff. And this case came up with an agreement that the parent aide would do a one-on-one parenting program with the mom on preteens. And the caseworker said, I will print out a curriculum, I will get you the information and the stuff to go over, and this will fulfill your obligation for the court for this service. So again, without mediation, they wouldn't have been able to think outside the box to come up with that arrangement. Parenting plan, 3 VDocket petitions filed. So as Anna had said earlier, if it's a VDocket, it has to have originated under an N. So lots of times when children are placed in care, there are relatives that come, from everywhere and say, I want visitation, or I want the child to be placed with me, which is great. And we love that. We love having children placed with relatives. This particular case that's what happened. The mom and the dad's family did not get along. And so both maternal and paternal grandparents filed for visitation. And I want to say it was the maternal aunt that filed for actual custody. So the judge said, you know what, send it to mediation, see if they can figure it out. And we were able to figure out, so the aunt did take the child and we were able to figure out a visitation plan so both sets of grandparents could see the child. Parenting time. So there is a judge that every time a newborn is removed from the parent, at the first appearance in court, the judge will send it to mediation. And what the judge will say is, you know what, it's a newborn. It's very important for this parent to have bonding time. So I want visitation 5 days a week. Everybody who works in the system knows that visitation 5 days a week is extremely hard to do, right? So we sit down in mediation, and in order to prep the mom or the dad for mediation, what I do is, I have the mediators call and say, look, you need to bring as many people as you can think of. So whether it's relatives, whether it's friends, whatever they can do, whether they can just give you a ride, whether they can supervise for an hour, but reach out to as many people as you know that you feel comfortable with that could help supervise these visits. And that's what we do. We sit down and figure out so this parent can get visits 5 days a week. Holidays are another huge example. Everybody knows that parents want to be with their children on holidays. When a child's not in the home of their biological parent, they're somewhere else, should it disrupt their holiday, right? Nobody feels like it should be disrupting everybody's holiday, but that's what parents want. They want to see their children. So if you send it to mediation, it's a chance to sit down and think, okay, how can this parent celebrate the holiday with their child, even if it's not on the actual holiday, right? So maybe it's taking the child to see Santa, to visit Santa. Maybe it's taking them to go see the Easter Bunny. Maybe it's taking them to, instead of trick-or-treating on Halloween, but maybe it's taking them to, a pumpkin patch or some other Halloween event. So what is a way that the parent can sit down and spend the holiday with the child, even if it's not on that specific day? CPR conditional surrenders are probably the biggest referral source. So the first, I'm gonna probably just go through 2 more cases and then kind of speed up a little bit because I only have a couple more minutes. There was a child with extensive medical needs. This case, actually, it was one of the very first cases I mediated. It was sent to mediation because the child was actually getting ready to go home. And what the judge said was, this child has severe medical needs. The parent needs to learn how to administer the medications, how to work with all of the medical equipment. Like, who's going to teach this parent? And the caseworker was like, well, I don't even know how, so I can't teach the parent. And the caseworker did contact the hospital and the doctors, and they're all like, nope, it's, we can't teach them because it's a liability. It's medical liability if we teach the mom and something goes wrong. So what they said was, who already knows? Obviously, it was the foster parent that knew. The foster parent is already doing it. So they sent it to mediation to figure out if the foster parent could teach the mom. I will be honest, it was one of my very first mediations. It was also one of the worst mediations I've ever done. There was a lot of hostility. There was a lot of negativity. There was absolutely no way that this foster parent and this mom were going to be able to sit down and have this conversation and figure this out, not even for the child. So I sent the case back and I sent it to the judge and I said, yep, nope, not happening. Here you go. So about 6 months after that, I got another referral for the same case. And I was a little surprised because, like I said, the child was ready to go home. Like, mom was doing really well. Child was ready to go home. And something must have happened because it was for a TPR, conditional surrender. So I showed up to that mediation and I was a little nervous because, like I said, I remember the hostility before. And I sat down with the group and I started doing the opening statement. And before I could even finish, the mom, the biological mom, says, I have something to say. And I thought, okay, great, this is not going to work. But I'm like, okay. And she looked at the foster parent and she said, you know what? I don't like you. I am never going to like you. But I know how much you love my child. So if I have to give up my child, it's going to be to you. They proceeded to reach an agreement. And like I said, it wasn't all sunshine and roses. It was not great, but they did reach an agreement. And one of the points in the agreement was that particular foster parent was the adoptive parent, which most counties will not do. They will not name people, but in this county, they knew how important it was to mom. So they did name the foster parent as the adoptive parent. I will say, without that mediation the first time, I don't think we ever would have gotten there the second time. I think that mom would have never understood how much that foster parent did for her child, right? I think she really needed that first mediation to hear about all of the medical equipment, all of the medications, everything that went into taking care of that child. So I think without that first one, we wouldn't have gotten to the second one, which is, a really important point, because not every mediation is going to come out with an agreement, right? Not everybody's going to come to some type of agreement. Sometimes it's just about having a better understanding of the other person.
It sounds like it's really a process, and it can be. So these are fantastic examples. I do want to just jump in really quickly because we have 3 questions already that I think would be really helpful for everybody to hear the answers to. Can I slide us ahead a little bit so that we can get to the question and answer portion?
Absolutely. I was actually, that was the last one I was going to do on there. So if you want to just stop here for Anna.
Yes, just quickly, that the mediators are trained to reframe and restate the statement. Sometimes hearing it from someone else makes it easier for other people to hear. This is really your opportunity to think outside of your box and come up with a solution that works for you and your family. Many of these cases, just as Sue mentioned, have tension, and people are feeling left out. This is a process for people to hear heard, and oftentimes once they do feel heard, they're able to move forward. All right, Rae, thanks.
Fantastic. And then I'm going to leave this slide up so that everybody has Sue's information. If you've got questions that we're not able to answer today or beyond that you think of later, feel free to reach out to Sue. You've got her email and her phone number. Sue, I'm just going to read these questions off, and it's Sue or Anna, whoever's best to answer them. We have one question. When relatives are identified as the placement option, are they typically a part of the mediation proceeding? And if so, how often do they receive representation?
So I want to kind of clarify that question that Ryan had asked. So if relatives are identified as placement option, is this before they're placed with the relative or after? Because if they're identified and the child's in foster care and they identify a relative and say, we'd like our child to be placed with this relative, then yes, absolutely, they're invited and they're part of that mediation. If the child's already with that relative, then it typically depends on what the issue is, right? Because if it's an issue about dad's service, say dad's doing anger management, and that's what the issue is that's preventing that case from moving forward, the foster parents are not typically invited to that because it has nothing to do really with the child and the care of the child. It's about dad's service. And then how often do they receive representation? It's like 50-50. It depends, depending on how long that child has been there in care, and whether or not the foster parents, if the child's there over a year, then the foster parents can get an attorney through the court. If they're not, and unless they get their own attorney, I mean, it's 50-50. Everyone's a little bit different.
Okay, thank you for answering the question both ways. It's appreciated. In the chat, we had a question: how does one train to become a mediator? I think we touched briefly on that, but if there's any more information you can give, that would be great.
Yeah, so there are local community dispute resolution centers in all 62 counties. A community dispute resolution center is funded through the Office of ADR, through the Unified Court System, and they provide basic mediation. So small claims, civil, community types mediation, that's your basic mediation. They typically have trainings for basic mediation. What they ask for is that if you show up and do the basic mediation training and they offer it for free, then they ask that you volunteer through so many cases. They also do, typically they do the parenting plans, the custody visitation support training as well. And it's the same thing, they ask that you volunteer. So people can go to any of the local CDRCs. And now a lot of things are virtual. You could probably look for any CDRC across New York State and be able to take the training. The other way to look is if you look through NYSTRA, which is New York State Alternative Dispute Resolution. They have an organization as well, and they usually list what basic mediation trainings are throughout the state.
Fantastic, thank you for that. We did have one more question in the Q&A. Sheila, I got your question about being qualified for the program, and if you can email me directly. I gave you my email address. I'd like to look into that a little bit better for you. Does anybody else have any questions for Sue or for Anna? I realize that we're running over just a little bit. I thank everybody for their patience. We had a lot of information that we got in a half an hour. Thank you so much, ladies, for joining us today. Really appreciate it. Again, anybody that's on this call, the webinar, you will be getting our YouTube slide deck and our PowerPoint handouts from today's call. And if you've got any questions, feel free to reach out to Sue, or you can reach out to me directly. Thank you. Have a wonderful day.
Thanks, Rae.